Court of Appeals, Division 1 is now in session.
Good morning. Please be seated. This is the time set for oral argument in Broadband Dynamics LLC versus SATCOM Marketing, Inc. Our civil number 17-0102. Each side will have 20 minutes within which to make their arguments here this morning. Appellant may reserve some portion of that for rebuttal, but it's up to you to keep track of the clock in that regard. We have read the briefs, we've been through the record, we've conferenced the case, so we're, I think, pretty familiar with at least some of the underlying facts and the issues that have been raised. So you might want to keep that in mind as you make your arguments here this morning. We're recording the proceedings both by audio and video. The video will be available in a matter of days on YouTube for anyone who wants to watch it. But because we are recording this, I would ask that as you approach the podium to make your arguments that you identify yourself and your clients for us. With that, counsel, you may proceed.
Thank you, Your Honor. Well, I'm not sure we're going to fill up 40 minutes with this argument as we were joking about, but...
Well, you don't have to take all that time.
I knew you'd say that. Well, Your Honor, I probably won't. But here's the bottom line to this, I think. And it is an interesting issue, as I stated below to the lower court. Basically, the issue is the interpretation of these two statute of limitations, the 3-year account, open account, as well as the written contract statute, 543 and 548. And frankly, reviewing the statutes, it doesn't give a whole lot of clarity, frankly. We believe and contend that where there is a written contract and the suit is based upon separate obligations within that contract, contractual obligations in that written contract, that it's distinct from the open account items encompassed by the 3-year statute of limitations. So we relied primarily on that Flory case, which the court actually used against us. But I think in doing so, with great respect to the court, I think the lower court erred because Flory just happened to have involved a separate guarantee that was attached to the underlying contract. And the court there did find the longer statute of limitations under the written contract SOL as opposed to the open account SOL under the personal guarantee. And I think what the court did below is say, essentially, well, because that was a separate contract and it wasn't intertwined in this case in this contract somehow, that it's distinguishable. But it's really not distinguishable because, as I see it, it's the obligation. The key is the separate obligation that's at issue that you're suing under the case law, not whether there happens to be a separate appended contract beyond the open account contract.
Mr. Wilenchik, if I could just ask.
Yeah.
First of all, the way I read the briefing is you are acknowledging, because I hate to use the term conceding, you are acknowledging that this contract is an open account contract.
I don't mean to mince words and sound like I'm evading you, but I think it's referred to as an open account contract, but there are separate obligations in that contract, is my point, that are not related to open account items, if that makes any sense.
No, I understand that. But my point is you are not contesting that this contract created an open account.
That's correct.
Okay. And the way I understood the briefing is that you're simply saying there is a separate cause of action besides the open account provisions that you believe are just simple breach of contract, damages, let's go forward, 6-year
Exactly.
statute of limitations.
It's really that simple.
Okay.
And I think, again, the Flory case is helpful to us because, again, while it didn't deal with this exact issue, I don't think the court's distinction of it, that it requires some kind of separate piece of paper that's part of the contract that you're suing under,
Except the termination provision in this contract is intertwined with the open account provisions, because you would look at the open account, what happened has transpired in the open account, to determine what would be the damages under the termination provision, correct?
No, I don't think so, Judge, with all due respect. I think the termination provision and damages are separate from the items of open account.
Well, I thought you would look at the last 12 months, you take the 3 highest months, an average of the 3 highest months to determine.
Oh, I see your point.
So,
Yeah.
I mean, they are intertwined. I mean, you have to look at.
Well, I guess it's a matter of terminology. I see your point. By looking at those items, though, you're not suing, and I think that is the critical distinction under the law. You're not suing on those items of debt. You're using those maybe to determine another damage. That's fair. But it's no more intertwined, in my opinion, than is the guarantee intertwined with the underlying contract, because obviously in that case, in the Flory case, you're guaranteeing the underlying open account contract. So I don't know how you can distinguish it on that basis. And that's why I say I think to keep this really simple, if you're suing on a contract debt, regardless of how you calculate it, because as I said, you can calculate the guarantee based on the open account contract as well. I think to keep a bright line, simple test, after reviewing the limited case law that I've reviewed, I think the best rule of law is that the contract statute of limitation encompasses a suit. It depends on what the obligation is you're suing under the case law. And if you're suing under a separate contract obligation that is not based upon the running open account items, to keep it simple, then I think you're suing on a contract basis. And the 6-year statute of limitation applies. And I don't know how else you would distinguish Flory otherwise. That's how I see it. And I acknowledge it's an interesting issue. And it's really sort of a first impression issue, although, as I say, Flory gives you some guidance. But this particular direct issue I haven't seen addressed exactly. But that's the best bright line that I could come up with. And I think it's simple and direct and harmonizes Flory as well. So if the court has any questions, otherwise I'll...
Actually, I had a procedural question.
Yeah, sure.
And it had to do with the prior litigation,
Yeah.
which I understand was litigated up to a point and then eventually got dismissed off the inactive calendar. Am I remembering this correctly?
Yeah, I believe so. I think the parties, I wasn't involved at that point, but from my understanding, the parties attempted to resolve the matter and couldn't.
Right. Then this suit got filed, and I'm wondering whether it was filed pursuant to the savings statute.
No, I don't think so. I think that had run.
Okay.
And as I said, I wasn't involved at the end of that, so I understand your question.
Right. Very good.
Okay, thanks. Any other questions?
No. Thank you,
Thank you.
counsel. Ms. Burke.
Thank you, Your Honor. May it please the court. And to respond to your last question, it wasn't filed pursuant to the savings statute. I had looked at that and it didn't apply.
Okay.
So there's no case law at all to support the notion that you take particular provisions from an open agreement and treat that as a separate contract. And
Do you need a separate contract? It seems to me that you can have separate causes of action arise from a type of breach of a contract. And so why would you need a separate agreement or a separate provision? I mean, it may be a separate provision, but it's still a separate cause of action, isn't it?
it would be an action on an open agreement. The express agreement between the parties was that this was an open account agreement. If you look at page 2 of the service agreement, not the terms and conditions, but the actual service agreement, about halfway down, it states, customer authorizes BBD to perform the necessary credit investigation to establish their account. This is an open account, and as Your Honor stated, the termination charge is intertwined with the usage billings that Broadband has acknowledged are part of the open account agreement.
So if it wasn't, would it make a difference?
I still don't think it would make a difference, but in this case, it is intertwined. And interestingly, so in the paragraph of the terms and conditions that establishes it as an open account, the purpose section 1B, it states customer desires to establish an open account with broadband based on this agreement and any applications that the customer has provided broadband. Then if you look at the next sentence, it reads, the customer understands that by its signature on this agreement, page 2, it agrees and promises to pay for all charges in accordance with the terms of this agreement. And that's the open account. And as Broadband alleges in their complaint, the termination charge must be paid in accordance with the payment provisions, just like the usage charges on the prior invoices. If you look at the complaint, they're seeking interest at a rate of 1.5%. That comes from the payment provision that's part of the open account. So they themselves, just by virtue of their complaint, are alleging that this falls within the open account.
So you don't see this as just hypothetically, as a situation where if the customer doesn't pay the last 2 months of their billings, where the first cause of action would be on an open account for those 2 months. The second cause of action is breach of contract for other terms
Right.
and conditions.
No, not at all. And there are other cases from around the country that we've cited in our materials.
I didn't find them particularly persuasive. You're talking about the Louisiana case and the
Yeah,
Texas case.
where there are interest and penalties and different things that come
There
from.
you're talking about in the Louisiana case, you're talking about statutory penalties.
Right.
But the main claim that they were being asserted in that case was that they had rebilled the services within 3 years, and they said that rebilling somehow brought up or reset the statute of limitations. That's not this case.
Right. I mean, yeah, they aren't directly on point. But if you look at the complaint in this case, in paragraph 11, Broadband alleges SATCOM was obligated to pay all invoices according to paragraph 2 of the agreement.
And
Then-
you would agree with me that the termination clause is not an invoice?
It
If
was
you-
invoiced. And that's what they're alleging in the complaint. The termination charge was invoiced as a termination charge.
But it's not invoiced as a service or a good exchange, correct?
Well, this isn't a contract for goods.
Well, it's a service.
right.
And
Right. It's based on what long distance would have been used had they continued to use long distance services with broadband.
Isn't that how you would prove damages anyway? I mean, assuming there was no termination clause, it's just a simple breach. You terminated this contract 6 months early. Wouldn't you prove damages by showing what's the loss of business that you would accrue, or that potential loss of business that accrued during that 6-month period?
But it would still be part of the open account. You'd still be invoiced for it. And if you look at paragraphs 11 and 12 together of the complaint, Broadband alleges that SATCOM was obligated to pay all invoices according to paragraph 2 of the agreement. And then the following paragraph 12, SATCOM breached the agreement by failing to pay as required. The payment provision, that's paragraph 2, is the same payment provision that applies to the prior invoices. You can't parse them out. What they're saying is, what they're alleging is that SATCOM did not pay all of their invoices in accordance with paragraph 2 of the complaint. So, I mean, Mr. Wolinchuk is correct that it comes down to whether you can parse this particular provision out from the rest of the open agreement, but the court got it absolutely right that they're so intertwined that it has to be considered part of the open account agreement. And they contractually agreed that this was an open account.
Well, there's no obviously, based on Mr. Wilenchek's argument here today, there's no dispute that it created an open account. The question is, can there be other cause of action accruing that wouldn't be prohibited?
Well, I don't think so,
statute of
because
limitation?
Broadband drafted the terms and conditions. They called the entire agreement an open account agreement. And if they wanted to carve out and say that any parts of the terms and conditions were not part of this open account agreement, they could have done that. Any ambiguities need to be interpreted against the drafter. SATCOM had no involvement in drafting it. This is a document that's on Broadband's website.
What about the general proposition in law that if it's unclear which statute of limitation applies, that we apply the longer statute?
If it's unclear, that would be the case, but I don't think it's unclear here. But I do agree that that's what the law is. But again, I think it's important to look at what part of the agreement in the complaint Broadband is alleging SATCOM breached, and that is the provision that directly is part of the open account agreement, paragraph 2, payment obligations. And in light of the fact that they're claiming the 1.5% interest, which is part of that provision, it's all part of the open account agreement. And they're alleging that that SATCOM was required to pay all of its invoices, and it didn't pay all of its invoices. That's the claim here. The only reason they're wanting to argue that it's not part of the open account is obviously because they don't want the 3-year statute of limitations to apply. Otherwise, if that wasn't an issue, they'd be telling you it's part of the open account agreement. So unless the court has any further questions for me.
Apparently
I will
not.
wrap
Thank
up.
you, counsel.
Thank you. A couple of quick points, Your Honors. First of all, I think the clear language of these statutes at issue governs. 12.543 talks about a suit on an open account. The other statute talks about suit on a contract. I agree with Judge McMurdy that the law is pretty clear that where there is any issue of which statute applies, I'm not sure that it says ambiguity, but I could be wrong on that. I don't remember off the top of my head, but I don't remember that. I think it's, if there's a question about which statute applies, the longer is generally the what the court will defer to. And we're suing not on the open account. We, in fact, abandoned that claim. Whether, I'll repeat, and I'll move on from there, whether or not portions of a written contract may relate to, in some way, items that may be barred by the applicable statute of limitation that apply to them is really not the issue here as far as I can see, any more, I'll repeat, than it was in Flory. You can make an argument there equally that clearly a guarantee applies and is intertwined with the underlying contract. I don't know how anyone could say otherwise, frankly, with a straight face, and frankly, I haven't heard counsel argue that.
Well, a guarantee is usually a separate document.
Well, yeah, but what is the distinction, I guess I would ask? I know I'm not here to ask you questions, but, you know, I would
You can ask, and we normally don't respond.
I know. Theoretically, I'll ask. I don't see the distinction, let me just say it affirmatively, between a separate document and a separate agreement.
Well, what about counsel's argument here just a minute ago that it was entirely within the power of Broadband as the drafter to characterize the agreement. The agreement here, she says,
Yeah.
The entire agreement is characterized by Broadband as an open account, as opposed to being parsed out.
Sure. I don't think with all candor that has any relevance to anything. What the document is titled is not dispositive as to what obligation specifically you're suing on under the statute of limitations. We could have called it anything, but I'm not trying to be facetious by that, but we could have called it anything.
So you're saying that the court's not bound by how the party characterizes a question?
Not at all. The issue under the statute in the clear language is what obligation you're suing on, and I think that under the Bean case versus Tucson Medical Center, the quote that I highlighted is, to be founded upon a contract in writing, the instrument itself must contain an undertaking to do the thing for the non-performance of which the action is brought. And that's clearly consistent with what I'm saying. The obligation is the key, not what you call it. And furthermore, as the court well knows, and I don't mean to sound pedantic or whatever, but the court, I'm sure, knows that under the modern interpretation of contracts, the party that drafted it is one factor. It is not dispositive of any meaning to be attributed to the document. And furthermore, if anything, that would be a factual issue, I suppose, as to what the parties intended. The court never reached those issues. And so I'm not sure the court needs to address those here in a de novo review anyway. But if the court remands it, that would possibly be a defense that would be raised to it, and we would deal with that in terms of negotiation, but that never came up below. Further, judges, I think beyond the Bean case, I would just point out that the service agreement here, beyond the open account debt, provided for exclusivity, which they breached. It specified a renewing term, which was breached, a minimum usage, which was breached, the liquidated damages remedies we've talked about, and therefore there are actual damages, even if the liquidated damage provision did not apply. And again, this is not a consumer case. I'd emphasize this is a contractual undertaking by two parties that are both sophisticated. But getting back to the point, and I guess as I said earlier, it really in some ways isn't all that complicated. You have two statutes of limitation. We're suing on a contractual provision. I don't see any law other than Flory that applies in terms of giving any guidance, unless the court has seen otherwise, that would give us any guidance here as to how to apply this concept of which statute might apply. And although I repeat that Flory didn't deal exactly with this issue, I think one can read into it the concept that if you're depending on what obligation you're suing under, this intertwined concept is one I think Judge Bergen, with all due respect, created out of Flory. But I don't think Flory ever said that within a contract that if you're suing on a separate contractual obligation that's beyond an open account, that you're barred from doing so because there needs to be a separate document attached to the contract. That would almost be, in my opinion, honestly putting form over substance and doesn't create a bright line rule that's of any meaningful use to anybody out there. I think the issue is, to repeat, if the debt that is being sued on is embodied by a separate contractual undertaking in the agreement, and that is the debt you're suing on, and not the open account portion, which, if you look, then the longer statute of limitations is deferred to based on how the statutes are written. By the way, I was going to say in passing, if you look at the history of open accounts and the case law relating to them, it's pretty old, but most of this concept came from oral agreements. Generally, people have oral open accounts because you don't have a separate contract. And that's true in this case as well for each and every thing the customer purchases under the contract. And therefore, it's kind of an enigma in some ways because they put it in the provisions dealing with oral agreements, if you see that, under the statute, dealing with it. And I think that's because if you go back to the history again, it's not very clear. The fact that somebody takes down something on a monthly recurring basis but has no separate contract applying to each and every purchase, became a problem. So in this case, the parties agreed to have an overriding contract dealing with those separate purchases. That's true. And that's why I answered your question, Judge. But that has nothing to do with separate obligations they undertook, as I repeat, usage and renewals and liquidated damages in the event of a breach. And here you'd be rewarding a breaching party, frankly, as some of the case law I've seen has talked about. You'd be rewarding a breaching party here. That's not a good rule of law, in my judgment, just because we didn't have another separate contract that makes these separate provisions clear and set out in a separate document. And as I say, I think that would be a terrible rule of law that is not justified by Flory, that the court didn't really say, but by this intertwined language, which I've not seen anywhere, said in essence. If there are no other questions, I'm kind of talked out.
All right. Thank you, counsel.
Thanks.
We appreciate the briefing that was filed in this matter and your arguments here this morning, concise and efficient. Thank you for that. We're going to take this matter under advisement. We'll issue a written decision in due course. With that, we are adjourned. Thank you.